Proceed in case number 110-241 in the matter of Pantaleon Flores.
May it please the court, Stan Haslett appearing for the Disciplinary Administrator's Office, and we're here as a result of a hearing which occurred on March 26 of 2013. On August 15th of this year, the respondent filed a pleading in which he declined to take exceptions with the findings made by the panel. The panel found violations of 8.4D, conduct prejudicial to the administration of justice, and 8.4G, which is conduct which adversely reflects on the fitness of a lawyer to practice law. This conduct arose out of a paternity action filed in Sedgwick County, during which the respondent was determined to be the father of his daughter. The misconduct in this case involved the respondent's failure to provide information to the opposing party, the mother of his daughter, and to not provide information as ordered by the court. There was also a finding of a failure to pay court-ordered child support and other obligations in a timely fashion. The recommendation of the panel, even though the panel said that the standards would indicate that suspension is appropriate under these circumstances, they took into consideration mitigating factors, and they concluded that the appropriate discipline was public censure, which was also my recommendation. My recommendation differed a little bit because the panel went on to say that should there be any further violations of the orders in this case or sanctions assessed, that there should be a 6-month suspension. I said that I would recommend to the court that we be required, should there be any further sanctions or violations of orders of the court, to immediately file an order to show cause with this court to have the respondent appear back before you and explain what had happened.
And that was where I started scratching my head, was the recommendation of the panel about this 6 months if there's another violation of the court order, because I didn't figure out how the mechanics would work. And I think, and the first thing that occurred to me was, well, are we talking about a final order of sanction? And so that would mean that the respondent would be incentivized to have to appeal any sanction in order to avoid the 6-month suspension that you would come up with. And so we'd sort of automatically be in the appellate process again. And this case has, I think, 3 times been to the Court of Appeals.
Correct.
And so I was trying to figure out, would that make it more likely or less likely that things would get resolved if we have this hanging around? So I guess I'd like both counsel to answer that question as to how they see that particular piece of I understand everything else. I kind of got that part down. But I don't see how I want to know what the trigger needs to be if there's going to be some other sanction that's involved. So your recommendation would be that if you hear of the district court entering an order, there'd be a show cause.
I would file the show cause.
And I guess what I need to know from the respondent's side is that enough, or are we going to have to talk about final orders from the Court of Appeals? And so, like I say, we're going to keep bouncing back and forth, because otherwise I see this as just prolonging dispute rather than resolving anything. And I think it's intended to be a hammer. I understand that, but
yes.
But because it's a hammer, it seems like it leads to more rather than less.
I hadn't thought it through the way you just presented it, but I still think that if there is a finding by the district court that there's a violation of the order, or that there is a finding that the respondent is not paying his child support in a timely fashion, that should result in an order to show cause.
The district court is the trigger rather than any later appeal. That's what my colleague's asking you about.
Right.
What if it were a suspended suspension? We've done that sometimes. Has that been discussed by the parties in this case?
No, but that would
It would have the
probably
same
work as well.
effect.
Right.
Doesn't answer the trigger question, but it would have the same effect, wouldn't it? And it would avoid the necessity of a second appearance before our court.
Well, it seems to me, if the violation ends up being, let's say that that he fails to pay child support. I mean, that's pretty cut and dried. I mean, if he doesn't follow the court order to pay child support. I mean, there are other things in this case that have occurred that have arisen in that have caused problems and have resulted in appeals, such as whether you can smoke in the home and how that's going to affect your visitation and that sort of thing. But the primary thing, I think, is that he pay his court-ordered support obligations. And if he fails to do that, I don't see that that's likely to result in an appeal.
What am I missing here? We're trying to figure out some incentive or some hammer for an attorney that's an officer of the court to obey an order of the court. We have child support orders or a court order.
Correct.
And we're trying to figure out some hammer to make an officer of the court comply with an order of the court. And I think that a hammer is if you're going to be a lawyer, you're expected to comply. And we've got 4 informal admonitions and a blatant disregard of court orders. And I'm understanding why I'm not understanding why that isn't grounds for some serious sanctions. If you're going to thumb your nose at the court orders, how can we be assured that you're going to fulfill your obligations as an attorney?
The panel struggled with that, and I struggle with that as well, whether or not suspension just right now is not the appropriate discipline.
What's your struggle?
I'm sorry?
What's your struggle? Pointing out what Justice Johnson I was going to follow up with that question, or he beat me to it. I don't understand the struggle to ask for something more than published censure, and I want to hear why what's your struggle about that? When we have clear violations in a case, he's an officer of the court, and we have prior misconduct.
Right. I don't know that I would call it a struggle.
I thought that's how you characterized it.
Any time, anytime you have to assess a situation and make a decision whether or not you're going to recommend suspension, because that's what we're talking about here, is the recommendation made by the panel and me, is that appropriate, or is it appropriate to suspend a lawyer? So many times before this court, that's the decision that has to be made, and that's the decision we have to make on what recommendation to make. Frankly, when I looked at this, I felt, and I don't look at it as a hammer, I look at it as if you don't follow the rules, you're out, you're suspended. My recommendation would be totally different. And frankly, I called down earlier this week to see, and I talked to Mr. Ambrosio about this to let you know what's going on in the case right now. Frankly, had there been any change in circumstances, had there been any other sanction, had there been any other order by the court that the court said had not been followed, my recommendation would have changed here today. So in my mind, it's not a hammer. In my mind, our recommendation changes completely should there be any further misconduct.
I guess I'll verbalize my struggle so a respondent can address it when it's his turn. Is I represented clients that went to jail for not paying child support, and then we're going to publish an opinion that says if you're an attorney, you get a slap on the wrist for being a deadbeat dad and not paying your child support, not paying it after you've been ordered to specifically pay it, and not to comply with it. And I guess if my clients had to go to jail, we're just going to give public censure. That's my struggle is looking at an attorney versus what this would sanction would be imposed if it were a non-attorney.
Well,
if you're understanding what, or if
I am
I'm making my point
saying.
here.
I do understand what you're saying, but I don't, under similar circumstances, I don't know that other individuals who are non-lawyers end up in jail. They may be found in contempt, and they may be released and told that you need to do what we're telling you to do. And in my mind, what I would like this court to say is that there are no additional chances that if you mess up again, that you will be suspended.
But you're willing to give him this one. That's the issue here. I think that Justice Johnson's asking about.
Well, yes.
Okay.
Does that factor in, though, his prior disciplinary record? giving him another chance, how does that factor in?
You're talking about his prior disciplinary
Right.
record before informal admonitions?
Mm-hmm.
Well, I note that the panel concluded that 3 were so remote in time that they didn't really consider those. They considered the one in 2010, not the one in 1995, 2000, and 2002, I think were the dates of those. Those did directly involve representation of folks, involved the diligence and communication issues.
So because they're distinct in terms of representing a client, that's why you don't think they're necessarily that significant here?
No,
in
I
addition to the
don't- I don't think-
remoteness?
I'm sorry, I don't think they're insignificant at all. I don't even think the ones farther back are remote in time. I think they're all significant.
I guess I'm just not understanding the give him another chance theory either, in light of those in particular.
Is it significant here that there is an ongoing financial obligation to the child and the mother that would be impaired if he were no longer able to practice law?
You know,
Is
I
that a
thought,
legitimate factor?
you know, I don't think it is a legitimate factor because I mean, every attorney that stands here before you who has the possibility of being suspended likely has a financial obligation to his or her family. So I don't think that can really be a factor. I will note it's stated in the panel report that the complainant in this case was not requesting suspension. She just said, you know, make this guy follow the court orders, which is, I mean, if he doesn't now, I mean, if you do not suspend him, if he doesn't now, then to me, the course of action is clear. With the permission of the court, I will, and I've talked to Mr. Ambrosio about this, I will tell you, if you want me to, what's happened in the case since the panel hearing of March 26th. And by what's happened in the case in Wichita. I don't know if you want that information or not.
I do.
Okay. I talked to the complainant, actually I talked to her this morning and a few days ago. The parties now are in case management. And the judge has said that no request for reconsideration or changing the child support can be made by the respondent unless the case manager gives his or her permission to do that. So right now his child support obligation is $918 a month. The complainant advised me yesterday that the respondent is current on his child support until paid up until December 1, 2013. The actual payment of the $918 was due on December 1st of 2013, and he has to obviously make that payment right away, or well, he's already past due on that. He's been ordered to pay approximately $30,000 in attorney's fees and has paid $22,000 in attorney's fees, and there have been some minimal payments that have been made over the last few months.
22,000 out of 30,000?
Yes, has
Okay.
been paid. So that,
On that, I had understood from reading I think it's the third Court of Appeals opinion, if I get the series right, that some of that was in dispute.
I think there is an amount, and I could be incorrect about this, but I think there's something pending before the Court of Appeals where $3,000 of that $8,000 would be disputed. Are there any other questions?
Anything further, counsel? Okay, thank you.
John Ambrosio, on behalf of the respondent, may it please the court. I hear all of the questions, I understand what you're saying, and my colleague doesn't seem to want to use the word hammer, but there's nothing wrong with this court having a hammer over somebody's head so he or she follows the court orders. And I understand that we're obligated to follow court orders, and I understand some people go to jail for not paying child support. He is current with child support. More importantly, he is following religiously all of the orders of the court. And I'll give you an example. There was a case manager that has been put in effect over visitation, not visitation anymore, it's called parenting time, over child support and everything. My client, very much because of his stream of income has gone down, wants to file a motion to modify. But he's not allowed under their system, as I understand it, to file a motion to modify until the case manager gives him permission to file it. So he has not filed that motion without the permission of the case manager, and he is waiting until that time. So he's following the orders of the court. He is current on child support. It takes him that full month to pay that $918 a month. It's difficult on him. I'm not excusing him for not paying before. He was wrong. He stood up to the plate. He admitted to the panel that he's wrong. He is following the orders of the court now. And we're not asking that he be given a pass. And I like the suggestion was made, suspend the suspension. I don't know how else to do it. And if he doesn't follow the rules of the court, if he doesn't follow the orders, he shouldn't be given a second chance. And my client admits that, accepts that, and is willing to do that. Since this case has been hanging over his head, there have not been any missteps or miscues. I ask you to follow the recommendation of the panel in this case.
Are you okay if that order says that the suspension kicks in if the district court finds him in contempt and not worry about whether it becomes a final order by, the highest court in the land kind of thing?
And you're asking me specifically, what do I think about that?
No, are you okay with it? Yeah.
I'm okay with it. I'm okay with anything that keeps his license at this point. I'm okay with anything that you fashion as long as he's able to continue to practice and he's not suspended and he has a published or formal censure. I'm okay with anything, which is not usually the case when I'm before this court, but I'm okay with anything that allows Mr. Flores to continue to practice, anything you can fashion. My client the respondent would like to address the court.
Of course.
I keep looking at the wrong justice. I apologize.
It's a bit confusing.
May it please the court. 5 years ago, when I learned that I had a daughter born to Miss Lank, who was then living in Wichita, Kansas, I never had any concept that my daughter's birth would cause me to be here in front of this court in this type of a case. And for that, I apologize to the court and to all concerned. Over the course of the last 32 years in the practice of law, I have endeavored to zealously represent my clients and conduct myself in accord with the rules of professional responsibility. The practice of law is very important to me, and I continue to enjoy the daily challenge and challenges it poses in our ever-changing environment. I will continue to work within the court orders that presently exist and the system to avoid anything that could be construed as untoward or a violation of any court order. And I assure you that my conduct will not cause me to be here again. Thank you.
Any questions for Mr. Flores?
Yeah, what happened here, Mr. Flores? What caused you to basically ignore your obligations? You had a duty to comply with, you've represented lots of people in domestic cases and all kinds of cases. What happened to your own case? What's your explanation?
Well, what started it was me thinking that I could represent myself. Because at the time I didn't have money to hire a lawyer. And then it just snowballed from there. At the time the case was filed, I had been divorced from my first wife of 26 years for about a year. Well, we were divorced in 06, almost 2 years, 2 years. And during that period of time, I hadn't filed a tax return for a couple of years. I hadn't filed my returns for 6, 7, or 8. And when this case came up for trial, I was trying to get them done so that I could provide the tax returns that I was ordered to provide at the hearing in September. And then my tax preparer was able to get the 06 return done. I had provided all of the details for my 08 income, and my estimate for '07, the tax return was ready, I think it was 2 days before trial. I faxed it immediately to Ms. Reddick, who was representing the complainant at the time, and it just went downhill from there. The court imputed $80,000 of income to me, net income to me a year, which my actual net income averages somewhere between 30 and 40 on an annual basis. And that started the ball rolling downhill. And that's what happened. I didn't have the money out of my income to pay the $918 a month of child support. I paid what I could until it got to the point where I was ordered to pay it, and I liquidated my retirement account that I'd accumulated during my first marriage and paid it.
Anything else? Thank you. Mr. Haslett?
I didn't reserve any.
Okay. Thank you, counsel, for your remarks. I'll take this case under advisement, and the court stands adjourned.